I welcome to my YouTube channel. Let's learn law for all. I have already discussed the topic of arrest of persons under the Criminal Procedure Code in sixth part. Now this is the seventh part of this topic, which is especially relating to the section 56 of the Criminal Procedure Code. So what is section 56? Section 56, its heading is person arrested to be taken before the magistrate. When any person is arrested without the warrant by any police officer, then such officer must take or send such arrested person without unnecessary delay, either before such magistrate who is having the jurisdiction in the case or before the officer in charge of police station. And if the case is such that such person can lawfully be released on bail even by such police officer making the arrest, then it is not necessary to take or send such person before the magistrate. So person arrested to be taken before the magistrate without unnecessary delay. I will discuss this case with reference to one case law. It is a case of, it is a judgment of Supreme Court of India, and it is reported in Supreme Court Cases, year 2005, volume 12, page 468. Who are the parties in this case? San Ganga Gowda versus State of Karnataka. So this case is relating to State of Karnataka. San Ganga Gowda. So what is this case? This case is relating to section 56 of the Criminal Procedure Code and section 330 and 348 of the Indian Penal Code. What are the facts in brief relating to this case? One accused person whose name is Gundappa, he was accused of committing murder. He was accused of an offence under section 302 IPC. So, in this particular case before the Supreme Court, there are in total 6 appellants. That appellant number 1 is the Sub-Inspector of Police, who is in charge of, for the time being, in charge of police station. And appellant number 2 to 5 are the police constables who are working under that appellant number 1, Sub-Inspector of Police. So, what is the case? That appellant number 1, who is a Sub-Inspector of Police, and appellant number 2 to 5 for constables, police constables working under him, they have arrested the Gundappa on the accusation of offence of murder punishable under section 302 of the IPC. So, in this case, that accused Gundappa was arrested on 19th October 1988 at 9:30 AM in morning. So he was arrested on 19th October 1988 at 9:30 AM at morning, but on the next day, that is on 20th October 1988, he died in police station at about 5:30 p.m. in evening. So here the case is that in the trial court, case was made against all these police officers, police personnel, for the offence committed by them under section 330 and 348 of the Indian Penal Code. The trial court acquitted them. Therefore, appeal was made by the state in the High Court. High Court acquitted only one accused person among the 6, but convicted remaining five appellants. 5 appellants, that is, one is, all that 5 appellants are police officer, police personnel. One of them is sub-inspector of police and others are police constables. So High Court convicted the 5 appellants before this case of Supreme Court appellants under section 330 and sentenced them to rigorous imprisonment. Besides, the High Court also found all of them guilty under section 348 of the Indian Penal Code and sentenced them for rigorous imprisonment. So, what is the case? In this case, High Court has considered the 2 important witnesses on behalf of the prosecution. One of them was the brother of that deceased Gundappa, to whom these police personnel have arrested on the 19th October at 9:30 a.m. morning, but who expired on the next day, that is 20th October at 5:30 p.m. evening. So here the prosecution witness 1 is the brother of that deceased who was arrested, and he gave the evidence before the court that when he approached the concerned police station for making inquiry why his brother was arrested, and he was standing outside in front of the police station, he saw that all these police personnel were assaulting his brother, that is Gundappa, in lockup room, and all these police personnel were beating this Gundappa with the sticks. Then another important witness is prosecution witness is the doctor who has conducted post-mortem report, and he said that there are various injuries on the body of that deceased Gundappa which sustained, which caused or resulted because of such beating by these police personnel with the sticks. So that medical evidence is also very strong. Then this eyewitness, the brother of Gundappa, he also saw that police personnel were beating his brother with the sticks. And another one important prosecution witness is the police jeep driver, who said that before the court, at the relevant period of incidents, appellant number 1, that is sub-inspector, was acting as police sub-inspector of the Rani Benur police station, and appellant number 2 to 5 were acting as the police constables under the appellant number 1 at said police station. They have arrested this Gundappa. So it is undisputed fact that at the relevant time that appellant number 1 was in charge of police station and appellant number 2 to 5 were acting as police constable in the said police station. So after considering all these evidence, High Court has convicted except one all 5 remaining police personnel for the offence of offence punishable under section 348 and 330 of the Indian Penal Code. It was the defense taken by the appellant number 1, who is a police sub-inspector, Cat. He has merely arrested that Gundappa, but he was not the investigating police officer. So he said that it was not his duty to brought this Gundappa before the judicial magistrate, but it was the duty of the investigating officer. So such a defense taken by that appellant number 1, sub-inspector of police. But when this matter came before the when this matter was before the High Court rejected this contention of the police sub-inspector, and Supreme Court also upheld the order made by the High Court of Karnataka. Why? Because it is observed in this judgment by the Supreme Court also that section 56 of the Criminal Procedure Code does not speak about the investigating officer. It simply speaks about the police officer making an arrest without the warrant. So, what was the defense taken by that police inspector? That I was not bound to take that arrested Gundappa before the judicial magistrate because he was not the investigating police officer. But court rejected the said contention because section 56 of the Criminal Procedure Code does not speak about the investigating officer. It simply speaks about the police officer making an arrest without warrant. As the evidence discloses that the arrest was made by the appellant number 1, and therefore appellant that concerned sub-inspector, that is appellant number 1, arrest was made by him. Therefore, it was his bounden duty to produce the accused before the magistrate next day within 24 hours. That is, next day before 9:30 a.m. in morning next day. But that arrested Gundappa was died on the next day in evening. Therefore, it was the bounden duty to produce the accused before the magistrate next day within 24 hours. The death of the deceased has since occurred beyond the 24 hours. It will amount to the wrongful confinement as contemplated under section 348. Therefore, Supreme Court held that there is no infirmity in the order passed by the High Court, and therefore this appeal filed by the sub-inspector and other police personnel before the Supreme Court, it is dismissed. So Supreme Court directed that the order of the High Court should be implemented regarding award of the sentence. So I will explain what is those section under which those police personnel were sentenced to imprisonment, rigorous imprisonment. First such section is section 330 of the Indian Penal Code. What it says, what is the heading? Voluntary causing hurt to extort confession. Voluntarily causing hurt to extort confession. What it says? Whoever voluntarily causes hurt for the purpose of extorting from the sufferer any confession or any information which may lead to the detection of an offence shall be punished with the imprisonment of either description for a term which may extend to 7 years. So this is the offence under section 330 of the Indian Penal Code. And the next offence is section 348. Wrongful confinement. What is it reading? Wrongful confinement to extort confession. What it says? Whoever wrongfully confines any person for the purpose of extorting from the person confined any confession or any information which may lead to the detection of an offence, he shall be punished with the imprisonment of either description for a term which may extend to 3 years. So, in short, once any person is arrested by the police officer without warrant, then that police officer has to take that arrested person before the judicial magistrate within the 24 hours from the moment of arrest. And if such police officer do not take that arrested person before the judicial magistrate, and he still keeps that arrested person in his confinement, in his custody, then offense of wrongful confinement get constituted. Offense of wrongful confinement under section, punishable under section 348, get constituted. So this is the very important provision. So I stop here, but I will discuss the similarly more important provision under section 57 of the Criminal Procedure Code. Its heading is person arrested not to be detained for more than 24 hours. So this is similar, one more important provision under the Criminal Procedure Code, which I will discuss in my next part of the video.